Students, now I will discuss an important topic of law of contract, and that is discharge of contract. In this lecture, I am going to discuss the definition of discharge of a contract, then modes of discharge of a contract, then there are two ways of breach of contract and the remedies of breach of contract. Dear students, now let us see what is discharge of a contract. Discharge of a contract is the end of the relationships of both the contractual parties. A contract is said to be discharged when the rights and obligations of both the contractual parties come to an end. That means the ending the relationships of the contractual parties is called discharge of contract. Now we shall discuss different modes of discharge of a contract. What are the modes? The modes of discharge of a contract are discharge by performance, discharge by mutual agreement, discharge by operation of law, discharge by impossibility of performance, discharge by lapse of time, and discharge by breach of contract. Now we shall see what is discharge by performance. This means that when performance is over, that means the contractual parties finish their responsibilities and obligations by doing the performance, then it is called discharge by performance. Now there are two situations where this contract can be discharged by performance. Discharged by actual performance, discharged by anticipatory performance. Now discharged by actual performance. A contract is said to be discharged by actual performance when the parties to the contract perform their promises in accordance with the terms of the contract, and discharged by attempted performance. So far as the tenderer of performance is concerned, a contract is said to be discharged by attempted performance when the promisor has made an offer of performance to the promisee, but it has not been accepted by the promisee. The second mode of discharge of contract is mutual discharge by mutual agreement. If both the contractual parties come to an agreement, mutual agreement, that they will discharge the contract, then contract will be discharged. Discharge of a contract by mutual agreement can be done in different ways. The ways are novation, rescission, alteration, remission, and waiver. The first way of mutual agreement for discharge in contract is novation. Novation means the alteration of the old contract and substitute it with the new contract. That means replacement of a new contract in place of old contract. In this case, the new contract can be between the parties who were involved in previous contract, or maybe with the parties who are new or different than the parties who were involved in old contract. The consideration for the new contract is the discharge of the old contract. Now we shall see an example of novation. A owes money to B under a contract. It is agreed between A, B, and C that B shall henceforth accept C as his debtor instead of A. The old debt of A to B no longer exists, and a new debt from C to B has been contracted. Rescission is another way by mutual agreement for discharging a contract. Rescission means cancellation of a contract. Now we shall see an example of rescission. X promises Y to sell and deliver 100 bales of cotton on 1st October at his store or godown, and Y promises to pay for goods on 1st November. X does not supply the goods. Y may rescind or cancel the contract. Another way, under mutual agreement for discharging a contract, is alteration. Alteration means alteration of the terms and condition of the contract. In this case, if both the parties alter or change the terms and condition of the contract, then it becomes a new contract and new obligations are created for both the parties. In this case, parties are not changed. Now we shall see an example of this alteration. X promises to sell and deliver 100 bales of cotton on 1st October, and Y promises to pay for goods on 1st November. Afterwards, X and Y mutually decided that the goods shall be delivered in 5 equal installments at Z's godown or store. Here, original contract has been discharged and a new contract has come into effect. Remission is another way of mutual agreement by which a contract can be discharged. So, remission means the parties who are involved in the contract where promisee accepts less than the promised goods or amount. Here is an example of remission. A promises to paint a picture for B. B afterwards forbids him to do so. A is no longer bound to perform the promise. Waiver is another way of mutual agreement by which a contract can be discharged. Waiver means that one of the parties waived the obligations of other parties in the contract. Now we shall see an example of waiver. A promises to supply goods to Y. Subsequently, Y exempts X from carrying out the promise. This amounts to waiving the right of performance on the part of Y. The third mode is discharge by operations of law. According to the law, if both the parties are not in a position to perform the contract, then it is called discharge by operation of law. We shall see what are the different ways where contract can be discharged by operations of law. By death of the promisor, by insolvency, by the unauthorized material alteration, and by the identify of promisor and promisee. By the identity of promisor and promisee. By the death of promisor. If the promisor promises to do something which is concerned with personal skill or unique capability, then if that person dies, then the contract comes to an end. So, by the death of the promisor, contract can be terminated or can be discharged according to law. By insolvency, when the person is declared as insolvent by the court, then according to law, he or she will have no liability or obligations to perform the contract. So, if it is declared by the court someone as insolvent, then contracts come to an end. Contract comes to an end according to operation of law. By unauthorized material alteration, if one of the contractual parties, without the approval of other party, alters the material of the contract, then the contract comes to an end. So that is also this way contract is discharged by operations of law. By the identity of promisor and promisee. When promisor becomes promisee, then contract comes to an end. So by this way, contract also discharged by operations of law. Here is an example by the identity of promisor and promisee. X draws a bill receivable on Y, who accepts the same. X endorses the bill in favor of Z, who in turn endorses in favor of Y. Here, Y is both promisor and promisee, and hence the other parties are discharged. Another mode of discharging the contract is impossibility of performance. If the performance of the contract becomes impossible, then contract is discharged. Now, this impossibility can be occurred in two ways. Impossibility at the initial stage for making the contract, and impossibility for supervening impossibility when it is going to perform. Now we shall see initial impossibility. Initial impossibility means the impossibility existing at the time of making the contract. For example, X agrees to sell his horse to Y. Unknown to both the parties, the horse was dead at the time of making the agreement. So, the agreement is void because of initial impossibility. And supervening impossibility. For example, X contracts to sing for Y at a concert for Taka 1000, which is paid in advance. X is too ill to sing. Therefore, X must refund Taka 1000 to Y because it was a situation of supervening impossibility to perform the contract. Another mode for discharging the contract is discharging by lapse of time. Now, if there is a time specified by both the parties for performing the contract, and when time is over, then the contract comes to an end. That means a contract is discharged if it is not performed or enforced within a specified period called period of limitation. The Limitation Act 1963 has prescribed that exercising right to recover debt in 3 years, and for immovable property it is 12 years. The last mode for discharging the contract is discharge by breach of contract. Now, breach of contract means contract is not performed by one of the parties. Now, this breach can be in two ways: anticipatory breach of contract and actual breach of contract. Anticipatory breach of contract. Anticipatory breach of contract occurs when the party declares his intention of not performing the contract before the performance is due. And actual breach of contract. Actual breach of contract occurs in the following two ways: on due date of performance and during the course of performance. When contract was due to perform, but one of the parties could not perform the contract, then it is called due on due date of performance. And during course of performance, that means contract has one of the parties or both the parties started performing the contract, but in the middle or at one point of performance or performing the contract, one of the parties failed to perform. Then it is called performance during course of performance. That means if any party has performed a part of the contract and then refuses fails to perform the remaining part of the contract, it is called an actual breach of contract during the course of performance. Now, if there is a discharge of contract, then what will be the remedy? In case of discharge of contract, the aggrieved party is discharged from his obligation and gets rights to proceed against the party at fault. Dear students, we are at the last stage of this lecture. In this lecture, we discussed discharge of contract. We discussed what is discharge of contract, what are the different modes of discharge of contract, then what is breach of contract, then what are the different ways of breach of contract, and the remedies of discharging a contract. Dear students, I hope this lecture will be useful for you to understand how to discharge a contract and what will be the remedies for discharging a contract. Thank you.